Every year, thousands of people in Florida open an LLC. They pay the state, they get the certificate. They print the EIN, and then they make the one mistake that quietly destroys the entire reason they formed the company in the first place. They skip the document the state never asked them for. And the document that decides who gets paid, who gets sued, and who walks away with the business if anything goes wrong. Most owners don't know it exists until a partner turns hostile or a creditor walks through the door. By then, it's already too late. All right, let's dive into this one. It's important. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Now, for 3 decades, I have watched Florida LLCs collapse over the exact same paperwork gap. The certificate from the Division of Corporations is not what protects you. What protects you is the agreement nobody told you to draft. So today, I'm going to walk you through the 4 reasons every Florida LLC needs an operating agreement before it opens up a bank account, signs a lease, or takes a single dollar from a customer. When you form an LLC in Florida, you fall under what I call the default rule trap. The reason it's a trap? Well, most owners never read the law that governs them. Florida has a statute called the Revised Limited Liability Act. And when you do not have an operating agreement, that statute writes the rule of your company for you. Every silence in your paperwork becomes a paragraph that the legislator drafted. Not you, not your partner, the legislature. Now, you're probably thinking that is fine. The default rules are probably reasonable. But here's the thing. The default rules were written for a generic, hypothetical LLC, not yours, not your industry, and not your equity split, not your buyout terms. They are reasonable for a company that does not exist, and they are catastrophic for the one you've actually built. Now, here's where it gets dangerous, and this is the part single-member owners never see coming. In Florida, the rules for charging orders, that is the legal mechanism that protects your LLC interest from your personal creditors, works differently depending on how many members the company has. The Florida Supreme Court made this clear in a case called Olmstead versus FTC. After Olmstead, the legislator drew a hard line. Multi-member LLCs in Florida get strong creditor protection. Single-member LLCs do not get the same shield. I call this the Olmstead loophole. And here's the part that should make every solo founder pause. A properly drafted operating agreement is one of the only ways you can document the legitimacy of the structure, address admissions of additional members, and build a defensible record before a creditor ever shows up. Without that agreement, you're not just exposed, you are exposed on paper, in court, in front of a judge who has no reason to give you the benefit of the doubt. Now, before I get to the third reason, which is the one that ends most business partnerships in Florida than any other single document, do me a favor and hit that subscribe button. I post every week on Florida business law, partnership disputes, and the contracts that quietly save companies. And it's free. So it takes 1 second, and it tells YouTube to keep showing you the videos that protect your business. Now, the third reason you need this agreement is what I call the silent partner war. 2 people start an LLC, best friends, brothers-in-law, old college roommates. They handshake on a 50-50 split. They never write down what happens when one of them wants out, when one of them stops working, or when one of them dies. And when one of them files for divorce and a spouse becomes entitled to half their membership interest overnight. The default statute does not solve this for you. It does not give a buyout price. It does not give you the valuation method. It does not tell the surviving partner how to keep the business running. It just sits there, silent. And that silence is what turns business partners into litigants. The operating agreement is where you bury the partner war before it even begins. Buyout terms, valuation formulas, drag-along rights, tag-along rights, death and disability triggers, non-compete language. Every one of those clauses belongs in the agreement. Not your head, not in a text message, in the agreement. Now here's the fourth reason, and this one catches people off guard because it is not even about lawsuits. It is about money. When you walk into a Florida bank to open up a business account, when you apply for a commercial loan, and when you sign a lease for office space, and when you take on an investor, every single one of those parties is going to ask for the same document. You guessed it, the operating agreement, not the articles of organization, not the EIN letter. The operating agreement. Without it, you look unserious. Without it, you slow down your own deal. And without it, the bank pulls back. The landlord raises a deposit, the lender reprices the rate, and the investor walks out. Now, the agreement is not just legal protection, it is operational currency. The companies that have it move faster. The companies that don't, they explain themselves at every turn. So here's the truth about Florida LLCs. The state will hand you a certificate. The state will not hand you a company. A certificate is a name on a registry. A company is a set of agreements between human beings. The default statute is not your agreement. The state form is not your agreement. The lawyer at the closing table is not going to write it for you in 5 minutes while everybody waits. The operating agreement is the foundational document, the one that decides who gets paid, who gets sued, who stays, who goes, and what the business becomes when the easy days end. Draft it before you need it, not after. If this video helped you, hit that like button and subscribe to this channel. I break down Florida business law, LLC structuring, partnership disputes, and the contracts that protect your money so you can make better decisions before the problem starts, not after. I'm Santiago Cueto, your Florida business attorney. Watch this video next where I reveal the 5 biggest mistakes to avoid when starting your Florida LLC.